Hello and welcome to this video on the language of mediation, which is essential legal English for international lawyers. So in this video we are going to master the art of diplomatic communication in cross-border dispute resolution through precise, neutral language that builds bridges instead of barriers. So imagine resolving a complex cross-border dispute without stepping into a courtroom and achieving that outcome simply because you used the right language. This isn't merely aspirational. It's the reality of effective mediation practice in today's global legal landscape. Mediation has emerged as a vital tool for international lawyers, offering a collaborative alternative to adversarial litigation. However, success in this arena often depends not on the strength of your legal arguments alone, but on the words you choose to express them. The language of mediation requires a delicate balance, maintaining professional authority whilst fostering cooperation, being clear without being confrontational, and remaining persuasive whilst preserving neutrality. This video will equip you with the essential vocabulary, phrases, and communication strategies that are needed to excel in international mediation. Why does language matter in mediation? Well, it reduces conflict. Carefully chosen words reduce tension, and they create space for a constructive dialogue that transforms an adversarial position into collaborative problem solving. It maintains neutrality. Neutral phrasing ensures that both parties feel heard and respected, preventing the mediator from appearing biased towards either side. It also facilitates understanding. Precise language eliminates ambiguity and ensures that all participants share a common understanding of issues, opinions, and agreements. It also builds trust. Diplomatic communication demonstrates professionalism and cultural sensitivity, which is essential for establishing credibility in international contexts. Mediation is an increasingly important form of dispute resolution or alternative dispute resolution. Rather than taking an adversarial approach, mediation encourages collaboration and understanding, and language plays a central role in this process. Unlike litigation, where terms such as fault, liability, or breach can escalate tension, mediation relies on vocabulary that reduces conflict and opens dialogue. So let's have a look at an example. Here we have some litigation language. The defendant is liable for breach of contract. This language is accusatory. It assigns blame and it immediately creates a defensive situation. It's appropriate for courtroom advocacy, but not in mediation. It's counterproductive. So you can see some litigation language here. Fault, liability, breach, And then we have the mediation language. An example is, it appears there may be a disagreement regarding responsibility for the contractual obligations. This phrasing acknowledges the dispute without assigning blame. It maintains neutrality and it keeps both parties engaged in finding a solution. We can see some mediation language here. Disagreement, responsibility, and concern. This reduces conflict. So let's have a look at language we can use for the opening of a mediation. The opening of a mediation session is crucial for establishing the tone, clarifying expectations, and creating a safe environment for dialogue. The mediator must project authority and neutrality at the same time. They must set clear ground rules whilst making all the parties feel comfortable and heard. They need to establish the purpose. For example, let's begin by clarifying the purpose of today's session. This frames the mediation as a structured process with clear objectives, helping participants understand what to expect. Then, the mediator needs to set some goals. Our goal is to reach a mutually acceptable solution. By emphasising mutual acceptability, this statement establishes a collaborative rather than an adversarial framework from the outset. Then the mediator needs to invite participation. Could each party briefly summarise their position? This polite request gives both sides an opportunity to be heard, whilst maintaining control over the process through the use of the word briefly. Clarification is perhaps the most important skill in mediation. Misunderstandings can derail negotiations, whilst clear communication builds momentum towards resolution. Let's have a look at some useful phrases. One example would be, if I understand you correctly, you're saying that. This technique demonstrates attentive listening and it allows the speaker to confirm or correct the mediator's understanding before proceeding. A mutual understanding check could be, let's ensure we're all clear on this point. By addressing all participants, this phrase prevents one party from dominating and it ensures that there is collective understanding. If you want to identify a specific concern, you could say, so the main concern is about the timing of delivery. Is that right? This focuses the discussion on specific issues rather than generalities, making the problem more manageable and solution focused. These clarification techniques serve multiple purposes. They reduce ambiguity, they prevent misunderstanding, and they demonstrate impartiality by giving equal attention to both sides. They also create natural pauses, and this allows emotions to settle. When rephrasing, the mediator should strip away any aggressive or inflammatory language whilst preserving the substance of each party's concerns. Now, emotions will arise during mediation, particularly when there are significant financial interests, reputational concerns, or long-standing relationships that could be damaged. The mediator's language must remain steady and respectful, acknowledging feelings without allowing them to dominate the process. Effective emotional management requires both empathy and control. A useful sentence would be, I understand this is a sensitive issue. Now, this validates emotions without endorsing a particular position. It shows empathy, but it stays neutral. If you need to redirect the focus, you could say, let's focus on finding a constructive way forward. So when discussions become circular or heated and there is anger, this statement gently steers participants back towards solutions rather than grievances. Sometimes we need to reframe the perspective. An example here would be, perhaps we can look at this from another angle. This suggestion introduces flexibility. Without dismissing concerns, it encourages creative thinking and it breaks any deadlocks that may have happened. These phrases de-escalate, they reduce tension, and they help redirect the conversation towards positive outcomes. The key here is to acknowledge that there are emotions present, but they are not allowed to control the mediation. International lawyers must also remain alert to cultural differences in emotional expression and conflicting communication styles too. The proposal stage is where mediation transitions from identifying problems to finding a resolution. However, solutions imposed by the mediator rarely succeed. Instead, solution-focused phrasing must sound collaborative rather than authoritative and imposed. Why? Because it invites the parties to explore options without feeling pressured or losing face. An example would be, would it be acceptable to suggest? The conditional would and acceptable frames proposals as possibilities rather than an obligation, and this preserves party autonomy. There could be a hypothetical exploration. What if we were to consider an alternative agreement? This what if reduces the pressure for commitment, and it allows parties to explore ideas without immediate agreement. Sometimes there are multiple options. The mediator could say one option might be two. By using one option, the mediator implies that other options exist, and this encourages creative thinking and preventing a fixation on one single solution. This collaborative approach encourages the parties to explore options without feeling pressured. The language emphasises possibility over prescription, using modal verbs might, could, would to soften the directives and maintain the parties feeling that there is ownership over the solution to this problem. Effective mediators present solutions as joint discoveries and not as imposed settlements. Using this inclusive language shows that there is that shared responsibility for the outcome. When parties reach a resolution, the mediator's language must shift from exploration to confirmation. This stage requires precision and formality to ensure that all parties share the same understanding of what has been agreed and what steps will follow. Ambiguity at this crucial stage can undermine the entire mediation process. A useful phrase to confirm understanding is "it seems we've reached an understanding." This phrase acknowledges progress whilst using seems to allow for final objections or clarifications before formalising the agreement. To summarise key points, a phrase like "let's summarise the key points we've agreed upon" could be used. This explicitly summarises and ensures that there is an alignment with what has been agreed It also creates an opportunity to identify any remaining misunderstandings before finalisation. To formalise the agreement, a phrase such as "we'll need to formalise this in writing" could be used. Now, this statement signals the transition from mediation to implementation, and it establishes expectations for documentation and enforceability. These phrases provide a structure and clarity at the end of the session. The mediator should go through all of the agreed terms in clear, simple language and confirm that both parties understand and accept these terms. They outline the process for drafting the settlement agreement and establish timelines for implementation and follow-up. This thoroughness prevents post-mediation disputes and ensures that the resolution is long-lasting. Even experienced legal professionals can sometimes escalate conflict without meaning to, but this can be because of poor communication choices. Being aware of these 3 pitfalls helps to maintain a constructive tone throughout the mediation process, and it prevents any derailment, any problems in there being productive negotiation. The first pitfall is adversarial language, quite aggressive language. For example, saying something like, "You're wrong about the contractual interpretation." It's better to say something like, "There may have been a misunderstanding regarding the contractual terms. Let's examine the relevant clauses together." A direct contradiction will create defensiveness. What the mediator needs to do is acknowledge there may be a possible misunderstanding, but also maintain dignity while addressing the issue. A second pitfall is interrupting or dominating. Interrupting a party in the middle of an explanation or not allowing the party to give their side that then allows the other party to dominate the discussion can lead to problems during that mediation and possibly it failing. So, useful language could be something like, "Let me ensure I've understood your point fully before we move on." Or, "I'd like to hear the other perspective on this matter as well." Balance is essential for perceived fairness and productive dialogue. A final pitfall is ignoring someone's emotions or their culture. Useful language could be something like, "I recognise this matter has significant importance to you. Could you help me understand your primary concerns?" Cultural intelligence and emotional awareness are fundamental in international mediation. So we need to transform adversarial language. And here is a practice exercise. So try to rewrite these adversarial statements into neutral diplomatic language. For example, if you say something like, "You're completely wrong about the facts," or "You're being unreasonable," or "Your client hasn't fulfilled any of their obligations," try to write these into more neutral language. Now, there are answers underneath. Try to write your statements before you have a look at the diplomatic alternative. So here we have 2 little skills challenges. Have a look at these 5 stages of the mediation: the opening, the clarifying, the managing conflict, proposing and closing. See if you can think of suitable sentences that could be used in each stage. And then we have a rewrite exercise. So have a look back at some of these more adversarial statements in this video and see if you can write them into more neutral language. If you would like to, you can share your answers in the comments section. So here we have a discussion question. What matters more in mediation? Clarity or neutrality? Well, clarity makes sure that all the parties understand the issues, the options and the agreements. If language is not clear, it's ambiguous, it can lead to misunderstandings, failed implementation, and the dispute renewing. Clarity needs precise terminology, explicit statements of agreement, clear articulation of interests, specific rather than general language, and a confirmation of understanding. Well, why is neutrality important? It maintains the mediator's impartiality, and it prevents one party from feeling that the other party is biased against them. Any feeling of favouritism can destroy trust, and it can ruin the mediation. Neutrality needs the mediator to be balanced and to give balanced attention to both sides, to use non-judgmental language, to avoid attributing fault, to be impartial, and to give equal validation to both sides' concerns. Without neutrality, mediation may not appear to be legitimate, and also the parties may not wish to continue with that mediation. So have a think about all these points and just think which for you is more important. Is it clarity or is it neutrality? Or do you need both? Effective mediators need to be clear about the process and the substance of that mediation, but they need to be neutral with outcomes and positions. The mediator must not advocate for one side or the other. They need to recognise that both parties have positions, and they need to find a solution that benefits both parties. A final takeaway here is that in international mediation, the mediator must be aware of cultural contexts. What sounds diplomatic in one culture may not be diplomatic in another. It could be weak, it could be evasive. Mediators need to build bridges and not barriers. So every word can either help find a resolution, or it could do the opposite. Effective mediation depends on language that builds bridges between these opposing positions, and collaborative, neutral language can help with this. So, mastery of mediation language shows expertise and it creates trust in global dispute resolution settings. Clients rely on lawyers who can navigate complex negotiations and be diplomatic. The mediation communication skills require ongoing practice and refinement. Try to analyse some successful mediations that you have either attended or you've seen in trainings, and try and develop your language so this can be used in your real world application. By mastering neutral, polite and precise legal English, international lawyers can enhance their professional communication and create lasting value for clients who are seeking efficient, relationship-preserving dispute resolution. Effective mediation communication is a learnable skill that distinguishes exceptional international lawyers from merely competent ones. Whether you're representing clients in cross-border commercial disputes, conducting internal workplace mediations, or serving as a neutral facilitator, language mastery is fundamental to success. Practice the exercises from this video today. If you're ready to improve your communication skills for mediation, negotiation, contract drafting, then specialised support can help you to develop the confidence and precision needed to use legal English effectively in high-stakes situations. Master the language that transforms conflict into resolution. I hope you found this video useful. If you did, please subscribe to this channel where there will be more videos in the coming weeks. Thank you and goodbye.